given that there'll be some people that are on or may see this recording that may not have been living all of these last few years, I'll give some background. So the background of this is back in 2016, we negotiated an agreement where we were trying to improve progression arrangements to improve salaries. That was done by taking the amount of money that the government had provided and reducing some salary increases to allow people from 1.1 to 1.7 to increase and progress beyond the 1.4, which was really based on the history where most people were getting cut off. We did that in good faith, and there was a clause in that that allowed the award to overtake the B rates in recognition of progression arrangements. Now, no one anticipated the award would do that, but what we saw, the state wage cases, which is where the award goes up each year at 1 September, generally follows the federal minimum wage case that comes out sort of late June and is implemented 1 July each year. What we saw in 2017, 2018 and 2019 is unprecedented increases in award rates in the federal case. And that's because the full bench finally stopped listening to the arguments of the big employer groups that if they gave big increases in minimum wage, it would mean people would get sacked. It's not the case. We've seen it in the US. They finally accepted the evidence. There was no correlation to reasonable pay increases and people getting sacked. So we saw these big increases that no one anticipated in 17, 18 and 19. What that meant is the award overtook 1.1s to 1.7s in 2017. It then, that's 1 September 2017. It then overtook 1.8s and above later in 1 September the next year and in 19. Didn't matter to them because there was a clause in the agreement that says for 1.8s and above, or the clause in the agreement that says the award could overtake only applied to 1.1s to 1.7s. 1.8s and above, if the award overtook, and when it did overtake, they got paid it. But what there was an obscure directive, the 12th directive issued in 2012, which is why it's 1212. And that had been put out by the Newman government when award wages overtook the core back in 2011. Now, it was overlooked by everyone, me included, none of us, the government, the whole lot, because it had never actually been used. When Newman put it out, it was because we were attacking him for suppressing wages, so the award overtook. But all agreements at the time had clauses saying if the award overtook, the wages prevail. So the Directive 1212 had never done any work, which is why we all missed it. But we shouldn't have, to be fair. In 2018, Minister Grace sent out a letter to all public servants under the core, attacking Alex Scott because we had said that in the case of the core, the government was really making a 0% offer because the 2.5 that they were applying was being applied to the EB and the award was already more than 2.5 above it. Grace sent out a letter to everyone under the core saying Together was lying, and one of the reasons for that is this Directive 1212 meant that no matter what was in the agreement, the award would prevail. Now that put a spotlight on the directive. She was wrong, by the way. It was still a 0% offer, but it was that attack that put a spotlight on 1212. And that was just before we started negotiating in 2019. So before negotiations started, we wrote to QCS saying, hey, there's a big problem here. If 1212 operates the way your government says it operates, it doesn't matter what we put in the agreement in 2016, the award wages will prevail. And this is a government directive. You can't wish it away. You can't pretend it doesn't exist. It's just a legal entitlement. It makes it different to Coles. And I know over the last couple of years, people keep raising the Coles decision. Coles was different. Coles was one where at the time of certification, the award was higher and therefore it should never have been certified. This was a question of, did the clause in the agreement which said the award could overtake, and you can do that in an agreement, was it legally overridden by 12.12? That was the key to it, and that's why it was different to Coles. So we wrote to the government, we said, we got a big problem here. The government basically wrote back, or QCS wrote back, basically saying, la, 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 we can't hear you. You did a deal. We're not going to address the legal issue that Minister Grace has raised. And then on top of that, they gave us an offer, which was 2.5 to everyone, would have cemented 1.1s to 1.7s being the lowest paid CCOs in the country by a country mile. And on top of that, take some cuts to awards, conditions and agreement conditions. And that was all the nasties around operational staffing, all of those sorts of things. Despite the largest level of industrial action that I think we've seen since the Joe era, the government refused to move when we went to arbitration. So we lodged a claim for 12.12. That delayed arbitration, because a key part of arbitration is what pay increase is fair, and unless you know what the start point is, how do you judge what's fair? So you had to know what the legal start point of people's wages were for 1.1 to 1.7 before you could arbitrate a fair pay rise. In 2020, we received the full bench decision rejecting our application. That was a big issue for two reasons. One is there was no way we were going to get in bargaining the sort of pay increases you'd get if we were right about 12.12, because, you know, it's up around 10%, but it was even 7%, 6 and 7% back there, because we've got some interim pay increases since then. Secondly, though, it was a bad decision. Our legal advice was it was wrong on a stack of levels. So conference delegates were briefed on the legal advice we'd received and agreed and decided to appeal, knowing that that was going to create some further delays. No one at the time thought the delays were going to be as big as they've turned out to be, and that's been a right pain. We received the decision on Thursday and we were vindicated. We have won the appeal. That's outstanding. It means we're going to see a bigger one-off increase to those, the 1.1s to 1.7s, the lower paid corrections that we've ever seen, bigger than we could achieve in bargaining. It vindicates all of those people out there that have copped a lot of criticism for going down this path. You know, I've got a list of people that have questioned my competence on Facebook, and not just mine, the union's competence. But we were always confident we were going to win this, and we were always confident that this would give us the sort of pay increases that we would simply not see in bargaining. So what does it mean? Firstly, everyone from 1.1 to 1.7 will be entitled to back pay from 1 September 2017. That's when the award overtakes the EB. As I said, 1/8s and above have always had the higher of the award of the EB, so 12.12 doesn't apply there. It applies to 1.1s to 1.7s. People now may be 1.8 and 1.9 or moved into the 2s or whatever, but from the period from 1 September 2017, if you were at any time in that period from 1.1 to 1.7, you will be owed back pay. The back pay will be payable on all wages since that time. That includes overtime, and it will be superannuable. So it is significant. When you look at the average increase at 1 September 2017 is about $50 a fortnight, and it's sitting up around $200 a fortnight now. In some cases, it is going to be significant money. Note, and the difference will be the difference between what you've actually been paid in every paycheck from 1 September 2017 to what you should have been paid if it was the award rates applied. Now, note there was the 2 interim increases we got QCS to pay. They go into what you were paid, so they're part of that difference. They're not over and on top of. We asked for those interims while 12.12 was being decided and while we're in arbitration. So the interims explicitly were to make sure we didn't fall farther behind. The back pay will apply to casuals. It will apply for people who have changed from permanent to casual or vice versa. And it will apply to anyone who's left QCS since 1 September 2017. It's different to an EB. An EB, you've got to be an employee at the date it's certified, because EBs apply at a point in time. This is retrospective, because what the decision says is from 1 September 17, you should have been paid the award. So it will be applied. But if you think about it, that is a mammoth task to calculate. And shared services are going to have to do it, and it is going to be immense, because, as I said, not only have you got, when everyone's individual increments are, when they got promotions, the 1 September cases each year take off the interims that we got from 1 September, if that's needed, and all the overtime, any sick leave, all of that. It is the shared services. It's not QCS that will do this work. I think they're going to have to employ people to do it, because this is enormous, and it is tens of millions of dollars in back pay for correctional officers. So I've asked the department for timeframes. They're trying to work out what they are. But I think you can anticipate you're not going to see a check next week. It is going to take some time, and we need them to get it right. We need to have the calculations right, because it's going to affect tax and all of those sort of things, not retrospectively. I think it gets paid now. Though that may not be the case. I'm not a tax lawyer. It may be because you're entitled from 1/2017, it will affect that as well. So I guess what I'm trying to say is this is not going to be quick, and it is not simple, but it is worth it. What we'll see, though, is 2 stages. So initially, there will be the increase to the fortnightly pays of 1/1s to 1/7s now. That's reasonably simple. I would anticipate that happening reasonably quickly. As I said, I've asked for dates on this, but the second stage is the back pay, and it will take longer. There's been a couple of questions of, can the department appeal? Theoretically, they can. Theoretically, they can appeal to the Supreme Court, and they have 21 days to do so from when the decision was released last Thursday. So they've got to 18th of March. I don't think they will. They would first need to identify an error of law to successfully appeal, and I don't think there is one. They were genuinely surprised when they won the first decision from the full bench, because they thought they were going to lose. So I don't think there's an error of law. I don't think they'll appeal on that. Secondly, they've now offered award rates in the EB, and EB offer, and I'll talk to that in a second. But whilst an appeal might save them some back pay, it's not saving them the ongoing cost, which is actually the big cost to government. And thirdly, it would just be a horrendous look politically. I just cannot see it happening. I'd make pretty substantial bets that I don't think they'll appeal it. So what does that mean for the EB and the EB offer? Now, we're very close, and I know people have been patient on this. There's been 2 to 3 meetings a week to try and get the drafting right. As you know, we got one offer that had a whole lot of nasties in it that we reject. That came late last year. We rejected that. We got the offer that we provided, or delegates have provided, in principle support to, subject to drafting. There's a couple of clauses in there that we just need to make sure are very tight, and that's the one about the handover, and where there's a face-to-face handover required. The way it's written there, or was written last week, I've got some new words that were sent through half an hour ago, and I think they'll resolve the issue, but you could drive a truck through what was all there. And also the aggregated shift allowance, we need to make sure we can still arbitrate those where the patterns are such that you'd be worse off compared to the EB. But that's almost done. So the agreements, I've got to check what was sent through half an hour, get that out to delegates, but I'm hoping to have that out in the next day or so for people to start looking at, so we can ballot it of members. We're going to ballot members first. The law now post-Newman, where he tried to ram through a number of agreements without parties signing off. The law now says the Commission cannot certify it unless all parties have signed off to the agreement. That's us. And our rules say we won't sign off an agreement unless it's been endorsed by members. So before it even goes to a ballot of all staff, as members, you'll get the say on whether the drafting is tight enough. We'll run that for about a week, then the employer has to do their ballot and then it needs to be certified. So it's probably about another 5 or 6 weeks away. Some people have said, should we stop now and go back into arbitration or go back into negotiation? I think there's 3 reasons why you wouldn't do that. Firstly, the only reason they've offered the award rates is because 12.12 was hanging. That's not true, actually. The other reason they finally got around to offering it was all the work a lot of members were putting in, picketing MPs' offices. We had Mark Ryan's office picketed, Grace Grace's offices picketed. It was ramping up from there. They were refusing to make an offer until 12.12 was handed down, and they changed their tune on after that. So got to be recognised that one of the big reasons we got the offer before 12.12 was handed down was not because of legal arguments or whatever. It was because of the action of members, targeted action with a real political purpose in mind, and that worked. But we got the offer because of that. So the award wages are in the offer. The offer is better than 12.12 though. The offer has a 2.5% increase payable today. It's retrospective once we get agreement, but if we get agreement and it gets certified, there is an additional 2.5% on top of the outcomes of 12.12 that's payable today. There is then also another 2.5% under the offer that's payable 1 September this year. So there's 5% on top of what came out of 12.12 in the next 6 months. There is also the 12.50 that will be payable as soon as we get a successful employee ballot. So not the union ballot, but the employee ballot up. So both of those things are better than the offer we've got. The other thing is all those nasties that were in previous offers, like, there was things like being able to adjust your roster with 24 hours notice, not 72 hours notice. All of the operational staffing and being able to move around posts. There was a whole lot of things that they were trying to put through. If we went back to arbitration, they're all back on the table. And what the Commission does is it cuts the baby in half. That's the way it deals with arbitrations. And we've got a decision that openly says in the last couple of paragraphs that we've had a windfall here. We negotiated an agreement, a deal, and we have now got this on top of that because of the operation of 12.12. If you think back to the first offer we got in 2019, they were seeking to take the progression stuff back out. All of those things would be back in. And there is a real significant risk that the Commission will go, well, you've got this windfall from 12.12, so we're not going to give you better than that, but we might give the department some of the things that they're seeking. So I think there is, in reality, all the risk for going back to arbitration is on the downside for us. I think that the chances of us getting better than the 12.12 outcome, 5% in the next 6 months, and 12.50, and avoid the nasties compared to what we might get, would say to me, and this is that I've started to have this conversation with delegates, but I think any perception that somehow we just get to start afresh now and all of that history gets written away and we just can go from there. I think there's a real risk around that. I think there is, in my view, locking this in and then continuing to build up to the next agreement and try to make improvements on work health and safety and so forth, has considerably less risk to it. So I think that's hit all the questions that I had before the meeting. I'm just going to the chat now. I've got 5 minutes more, so I'll just see if there's, I see there's some questions there. If I can work out how to make the chat bigger, it'll make my life easier. All right, so if you've got questions, you can put them into the chat. Paul Ross, I think Paul Ross has asked a question about how will the tax work on a lump sum payment? Can it be 4 payments, or is there no way around it? Even if it's 4 payments, Paul, if it's still in the financial year, and again, this isn't financial advice, I'm not an accountant, got to say that. Even if it's 4 payments over the 12 months, it's still going to be that amount. The issue is going to be whether it can be amortized over the previous years. And I just don't know the answer to that. There's a question from Sophie on how do we find out the actual figures of the new award rate. If you have a look at the figures in the offer, that is the award rate, the figures from 1 September. But also after this, we can probably send out an update to where it is. If you go to the Queensland Industrial Relations Commission website, it's just qirc.qld.gov.au. And once you get there, you can go to awards and find it. But the simplest is the offer that they put out, the 1 September 2021 rates that they've got in there are the same as the award rates. Question from Steve there. No, we haven't. His question is, do we have a calculator ready yet? What we're seeking to do is put together a calculator that will give you a rough idea of the sort of back pay. So we'll need to get, we'll do that by sending out a link where you send an email that you put your start date, your increment date, what level you're on now, and we can then work out a rough amount. It will be rough because it won't take into account any of the overtime. It will just work out the difference between the award rates as of 1 September and what you were getting paid with your increment dates and the interims and so forth. We were going to be doing some work on that, but as I said, we're completely flooded out at the moment. So our capacity to get that done this week's probably going to be difficult, but we will be trying to get that out just so you can get a ballpark idea of what the back pay is likely to be. So I'm conscious that is there any increase from Daniel? Is there any increase in the leave allowance? I think you're talking about the leave loading. No, there is not in the agreement. The leave loading is separate to aggregated shift. And in fact, when the aggregated shift allowance was first brought in, when you moved to 12-hour shifts in the late 90s, it was 25%. So when you went on leave, you still got more. What's happened over time is it's been negotiated up. So it is a problem. It is a problem that we're going to have to deal in future agreements, that the gap now between the leave loading that you get when you go on holidays is now considerable with the ASA, and people need to be aware of that and understand that that's going to be a problem. But the two are not linked. The leave loading sits in the award as compensation. But yeah, I think, you know, people were disgruntled previously when they got a slightly reduced paycheck when they got on leave. It's going to be more now. People need to be aware of that, and that they need to factor that in until we can look to change that in future agreements. That's all the questions I've got here. It's 12:30 now, so thank you for everyone for this. We will put the recording up. If there are any other questions, put them on now, and we can come back. For example, Steve's just put up one saying, can they drag the back pay out for an absurd amount of time? No, we'll push them to a certain point, mate. We need to get a calculation. Apparently, there's questions in the Q&A from Ashley. I'll need to find out where they are on this, unless you can put them in, Ash. We'll find out what their indicative timeframes are, but no, they owe you it, and they owe the back pay. That needs to be done reasonably. One of the questions is, some people were overpaid in 2017 and had to repay this overpayment? Yes, that will be returned, because that will be part of the back pay you get here. So yes, what happened in 2017 is the department forgot about the clause that said that they didn't have to pay when the award went over, and paid everyone from 1/1 to 1/7 the award rates. That was contrary to what the agreement said, and before 12/12 happened, so it was recovered. That will now be returned as part of this. And the other question is the question about CO 19. Is there anything in progression? There's not. There is what is in the offer. We were pushing for a review of the class structure, which I think it isn't in the offer, but they still want to do. I think they recognise there's problems, and in that we were pushing for the ability to push people up who are on 1/9, but the offer is as it is at the moment. And there's an exact date to back pay on 12/12. As I said, it will be from 1 September 2017. When it is going to be paid, I do not know. I've asked the department. They will come back to me. But as I said, there will be two stages. One will be your paycheck will increase to what you're supposed to be paid, because that's fairly simple. But the calculations on back pay are going to be enormous, so that is going to take some time. As soon as I've got indicative timeframes from the department, we will let people know. Thanks, everyone. We'll record this. Make sure you let people know that it's going to be available. We'll put that up. If there's any other questions, if you send them to corrections@together.org.au, we'll seek to update there. Look out for a draft EB to come out for comment from delegates this week. It's very close, and we'll go from there. Thank you, everybody.